Good morning, class. This week we will finish up on trademark infringement and dilution, and then go on to the next major topic in the syllabus, which is tort law. And today we are going to continue on the topic of trademark infringement and trademark dilution on the internet. As I had indicated in the previous lecture, the functions of trademark is very different from the functions of domain names, right? And basically, you find that although they are very different, one is used in the context of businesses so that consumers can distinguish products or services that are similar, and therefore a trademark has to be very distinctive, right? Then on the other hand, you've got domain names, which basically constitute the address, right, in the internet. And sometimes when people register the domain name, they may, take certain famous trademarks as domain names, and sometimes they may even have no, intention of using it in the context of their business. All right. So you have got things like what do you call it, cyber squatting or typo squatting emerging in that context. But the important thing for you to understand is that when it comes to cyberspace, sometimes these two will merge, and then there would be, certain conflicts arising from people who are holding the domain name or holding the trademark. Okay, so that's basically what we have looked at up till now. Right now, one of the things that businesses have to be aware of when they are doing online business is that there is a possibility that when they actually have got websites and their trademarks are displayed in the websites, there could be a possibility that other businesses may actually infringe their trademarks. In fact, it is much easier to infringe trademarks in cyberspace compared to the physical world. Similarly, there is also a risk of trademark dilution, which means that when you actually put your trademarks in cyberspace, other businesses may use that, and for a different business or for a different service, but they may use it in a way that your trademark becomes diluted. All right. Now, why is dilution bad? Because in many ways, it is going to, diminish the value of your trademark. So remember, keep remembering this when even after you graduate, that trademarks are what, is a form of asset, intellectual property asset. And the more famous your brand becomes, the more famous your trademark becomes, it will acquire value, right? And that value is very important. So when trademark dilution happens, all right, definitely what's going to happen is your assets will be devalued, or in other words, the value of your assets are going to decrease. Okay, that's the reason why a lot of these cases are brought by famous brands. When other brands, try to either imitate or try to use their trade names in a manner that their trademark becomes diluted. Okay, so as you can see, when you bring a case against someone else for trademark infringement, there are three elements that you have to prove in the case. The first element, of course, is that you have a right over that trademark, and that right arises either through your use of that trademark or through registration. Okay, so that's the first thing you have to prove in court, that that trademark belongs to you, either through usage or through registration. Now, the other element that is very important for you to show is that you had used that trademark in the context of your business. or in other words, there was a commercial use of that trademark. And then the third element that you got to show is that, that there was some form of confusion arising from the way the trademark was used by the defendant. All right. So those are the elements that you need to prove in trademark infringement. On the other hand, for trademark dilution, the elements required for you to prove in court are slightly different. All right. So, for you to say that your trademark was diluted, in other words, you have to actually show that your trademark is well known or that it is famous. All right. And so that's the first thing you got to prove in trademark dilution, right? To show that your trademark has got value or a lot of value, then you have to show that it was famous or it is famous, right? So examples of such famous trademarks are Coca-Cola, you know, Howard University, whatever, for educational purposes. Okay, when you put the name Harvard University, that means that basically that education has got quality, right? Or McDonald's when you talk about fast food. Okay, so that's the first thing you must show, that the mark is actually famous and is very well known and has got tremendous value attached to that mark. Second is that that mark by you was actually for commercial purposes. That means you had used it in the context of your business and for making profits, right? And third, you have to show that there has been some form of blurring or some form of tarnishment when the defendant had used that trademark in their business, right? So basically, these are essential elements in trademark dilution. So when you talk about trademark dilution, there are two types of dilution. One is through blurring, whereby when the defendant is using the mark over time, the public is no more going to see your mark as distinctive. And I've shown you the video in the previous class where they used the perfect example of Coca-Cola as well as Rolls-Royce, right? And then the second is tarnishment, when the defendant is using that trademark uh, for maybe it's a different type of business, but maybe it's a business that is particularly not really regarded with high respect in business communities. Perhaps they are dealing with certain products that may actually bring your trademark to be tarnished. All right. And so because now your trademark is associated with another product or service that is either of inferior quality or maybe in some way unsavory. Unsavory meaning, for example, in relation to certain activities which society do not really look highly upon. All right, so that's the elements required for trademark dilution, right? Now, if you look at the proof required for trademark dilution cases, of course, once again, the plaintiff must prove that he or she owns that trademark or that particular business owns the trademark, and also that that trademark is very distinctive and very famous. And then finally, the use by defendant is causing that trademark to be diluted. Right? Famous case with respect to that, which you can actually see on the chapter that I have uploaded, a few weeks ago. The case is of Washington Speakers Bureau Incorporated versus Leading Authorities Incorporated. Now, in this case, the court found that there was infringement, all right, infringement of the trademark because it caused confusion, all right, in the minds of consumers as both parties were involved in identical services. Okay, now defendant had used the plaintiff's trademark as its domain name with bad faith to attract plaintiff's business. But the court held that there was no trademark dilution because plaintiff trademark was not famous. So as you can see, for trademark dilution cases, it is very important for the plaintiff to prove that their trademark is famous. So in this case, the court said that there was no trademark dilution because plaintiff's trademark was not famous. Okay. Now, the next case, two cases, is about dilution by tarnishment. All right. And this happens when a plaintiff's mark is associated with defendant's, product, which is also using plaintiff's mark, but they're using it for a different product, which is perhaps of inferior quality or is unsavory. All right, unsavory meaning usually when it is dealing with certain activities that are not really looked highly upon by most people in society. Now you will see that through these cases. The first is Hasbro Incorporated versus the Internet Entertainment Group. All right, and the second is Toys R Us versus Akawi. All right. Now, in the first case, all right, now Hasbro Incorporated is actually should I say, a business that deals with children's games. All right. And it's very famous in the United States because they come up with a lot of different varieties of children's games. And then the Internet Entertainment Group, they deal with a different type of business, particularly pornography. All right. So here, what happened was the maker of a child's game brought a case against the Internet Entertainment Group, which is a business dealing with pornography. So the famous family board game called Candyland was being used as a domain name by a pornographic website. All right. So the Internet Entertainment Group had used this famous family board game called Candyland for one of their, pornographic website. All right. Now here, the court prevented defendant from using this domain name because the court held that the use of that particular, domain name, which is actually the name of a famous family board game produced by Hasbro Incorporated, will actually cause trademark dilution by tarnishment, and it may degrade the quality of the family game, which is the Candyland mark. So here, the court held in favor of the plaintiff and said that the use of that domain name by this pornographic, business did indeed cause trademark dilution in the form of tarnishment. All right. The next case is Toys R Us. So you all know Toys R Us, right? They deal with children's toys and games. All right. And then you have the other business called Akawi. They are defendants in this case, and they use the name Adults R Us. Instead of Toys R Us, they use the name Adults R Us. All right, to do or operate an internet site and shopping service which catalogs a variety of sexual devices and clothing related to that. All right. Now, so here the court again ordered the defendant to stop using that name in its internet website. All right, or as its internet domain name, and ordered the defendant to cancel their domain name registration. As you can see, these, the plaintiff was dealing with children's toys and games, and for the defendant to take that name, although they altered it a little bit, but it still sounded quite similar. So it could bring about tarnishment, all right, dilution by tarnishment. And so you can see generally the courts are quite particular when it deals with children's products, right? And they don't want, all these, pornographic websites or websites dealing with, pornographic kind of, products to actually use such domain names, which are commonly associated with children's products, right? So that is dilution. Examples of two cases dealing with dilution by tarnishment, all right? If you know the word tarnish, basically when you look at say a brassware, right, or gold, when it's shining, right, it's really bright, right? When it's tarnished, it looks dull. So when a trademark becomes tarnished, it basically means it is no more, doesn't look that, good anymore because its name has been tarnished. Okay. Now, dilution by blurring. Normally, this blurring doesn't take place immediately when the defendant uses it over another product, right? But it happens over time. So, for example, if you take the name Coca Cola, suddenly I use the word Coca Cola for restaurants, I use the word Coca Cola for shoes, I use the word Coca Cola for pens, or I use Coca Cola for food products. So then over time, when different companies are using the word Coca-Cola, the name becomes blurred because consumers, normally will not straight away connect the name Coca-Cola with the drink anymore because now it's used over a range of products that are very different, right? So that is dilution by blurring, okay? Now, so there's another case about trademark dilution, right? And this is also dealing with Toys R Us, right? And here you will see that there was this case where dealing with trademark dilution, all right? Here, defendants used the name Gunzaras, all right, uh, for an e-business selling firearms like, guns and so on, right? So here they registered the domain name Gunzaras, all right, and for selling all these firearms, all right, and basically, right, this Toys R Us brought this case against the defendants, but in this case, the court held that the use of this name Gonzalez did not infringe or dilute the famous plaintiff's Toys R Us trademark or trade name. All right. So the infringement claim failed because the consumers, according to the court, the consumers are not going to be confused by defendants' use of the domain name Gunzaras with Toys R Us, right? So here they're dealing with different products on the website. Therefore, according to this lower court, the lower court decided, the district court decided that there was no possibility of either blurring or tarnishing of plaintiff's name because defendant was operating a small retail store and consumers will not connect it with plaintiff's business. However, plaintiff appealed against that decision and they went to a higher court. Now, however, in the higher court, the court overruled the lower court's decision, all right? Especially the last argument that says that there was no confusion or deception, right? So basically, according to the court on appeal, they said that that confusion or deception is not necessary for trademark dilution cases. All right, confusion and deception is only necessary for trademark infringement cases. So here, they, because consumers may think, oh, maybe Toys R Us decided to open another, business, and now they are dealing with a retail gun store, right? So consumers could easily believe that there's a connection between these two companies, and therefore dilution can take place because selling guns may not be something very very positive, except of course in US, right? But anyways, the Court of Appeal said confusion is not a necessary element in trademark dilution, all right? And therefore, they said that there could be an affiliation made by consumers between these two, the business selling the guns and also Toys R Us, right? So that was the case of this Toys R Us. Huh? The next case is about Vanna White, okay, White versus Samsung, right? I don't know if some of you have seen the game show called Wheel of Fortune. The lady who spins the wheel, right, is she became very famous, right, in the 80s, 90s, and I think the show is still going on, right? And this game show became really, really famous in the United States and later on around the world. And Vanna White and the host of the show, Pat Sajak, also became very famous. All right. So what happened was the Samsung, they had used this kind of like a doll that kind of looked like Vanna White, and this doll was like a robot. Like the face, of course, was not Vanna White's face, but it was like a robot-like face, and was spinning the wheel, and the wheel looks just like the Wheel of Fortune. All right. And when Vanna White one day saw this advertisement by Samsung, and she was like, wait a minute, that looks like me in the show. It looks so similar that people are going to construe that, or may even think that I've got something to do with Samsung, right? So issue arose. Did the defendant violate the Lanham Act or the Trademark Act of the United States, because she herself became so famous that she herself, Vanna White, has got now a distinctive persona, all right, meaning she's associated automatically with the show Wheel of Fortune, and Wheel of Fortune people automatically, when they think of Wheel of Fortune, they think of Vanna White spinning the wheel, all right? So she became a distinctive or famous persona, right? So question, was there a violation of the Lanham Act or the Trademark Act, right? Or and the other issue that arose was parody a defense to the trademark claim, right? So what is a parody? Parody is like remember I explained it in the previous lecture. Parody meaning when somebody is using their website to poke fun at certain people, right? So could this be construed as a parody where they're making fun of Wheel of Fortune as well as Vanna White? All right. Anyways, all right, here the case was dismissed by the district court, right? Vanna White sued Samsung, right? But when it went to the first level court, which is the district court in the United States, the district court dismissed the case. But then when they actually, she went and appealed against the decision, the Court of Appeal reversed the decision, meaning they made the decision in favor of Vanna White, which means she must have obtained some form of damages for the case, and Samsung was prevented from using that particular robot. Okay, so that's the example of cases arising in the context of trademark infringement and trademark dilution. All right. Now, so what are the 8 factors? In this case, the court identified 8 factors that may cause confusion, all right, in the minds of the consumers. One is the strength of the plaintiff's marks. They look at how strong your mark is, meaning is it famous, right? Second is it, are those two goods related or not related? All right. Third, are these two marks very similar, the trademarks? Fourth, was there some evidence of confusion, right? Fifth, were marketing channels used, meaning was it used for the purpose of advertising, right? And is it going to in some ways involve purchaser care? All right, so you're going to study tort law, so you're going to talk about duty of care, right? So is it going to involve in somewhere some kind of duty of care on the part of purchaser, you know? And then, a defendant's intent in selecting the mark. What was the intention of the defendant? Uh, Maybe they did not have any intent to either cause any infringement or cause any dilution. All right. Or is it possible that plaintiff wanted to expand it into the goods that right now the defendant is using, and now that since the defendant is use that trademark in the domain, or in the website, they have actually, affected the right of the plaintiff. So was there a likelihood of expansion of the product line by the plaintiff? All right. Now, if you look at the strength of mark, especially for celebrities, right? Sometimes you see in the advertisement world, they use celebrities to promote certain products, right? Because the celebrity has got a strong persona, right? So in that situation, people may buy the products because they like that celebrity, or they associate that celebrity with something very positive. So here the issue was Vanna White unknown or well known, all right, to the segment of the public in which it was marketed, all right? So if it was well known, then there's a likelihood of confusion because, a lot of the people who are watching Wheel of Fortune may think that Vanna White is actually promoting this Samsung product, right? So that's the issue, whether she was well known enough to have caused confusion in the minds of the public, right? Now, so if you look at that, in this case, what did the court find? The court find that White's goods were her televised performances. So that means that her basically herself, right? She's the one who's on the show, right? And what's her goods here is her persona, right? Which is coming from her performances in the Wheel of Fortune. And second, was there a lot of similarity between the robot and the white? Right? Of course, anyone could see that it was a robot, but people may actually get the wrong impression that even though the robot doesn't look like Vanna, I mean, you get the impression it is Vanna White, but although it's a robot, but then they may think that Vanna White is actually, endorsing the VCRs, all right, the video recorders, okay, and and although the defendant did intend to profit, definitely, right, the defendant had intention to profit by giving the impression to the consumers that maybe when a white is endorsing their product, right? Now, of course, the Samsung had also brought up the defense of parody. They were saying that they were poking fun of this particular personality, but the court rejected that as a defense, right? So this case involved a true advertisement run for the purpose of selling Samsung VCR. So in other words, they're saying buy Samsung VCR because someone famous is associated with it, or at least they wanted to give that impression to the consumers. All right. Now, so as you can see, all right, basically this is really a problem, right? for businesses, and especially if you're going to do an e-business, you have to keep an eye out to see whether people are infringing or possibility of diluting your trademark. Okay, and that's very important that you have to prevent that, right? Because otherwise the value of your trademark is never going to go up. Okay, now if you look at I asked some of you to try to attend that video, sorry, the web um, uh, web conference last week, and they were talking about Apple. All right, and why is it that the brand name Apple has got highest value of any brand names in the world right now? It's the top right now. All right, it's because they know how to safeguard their the innovations, including their trademarks. Because anybody tries to do anything with their either trade name or trademark or even their inventions, which they've got many, a lot of patents and designs into their, under their name. So they are going to sue, right? And that's how they protect their trademark and their trade name and their inventions. Okay, now if you look at cyber pirates, all right, you know what pirates are, right? Long ago, pirates are people at the sea, and they go and they loot other people's property, right? That's what they're called, pirates, right? So you have now what you call cyber pirates. Now these cyber pirates, they register the domain names with network solutions, right? And as you know, registration is on first come first serve basis. All right, and then they try to get a lot of money from the trademark owner. All right, so now you've got this new act in the United States called the Anti-Cyber Squatting Consumer Protection Act, which protects trademark owners from online cyber piracy. All right, of course, they have made some changes to the Lanham Act. All right, and it basically, if the person has registered the domain name with bad faith intention to profit from somebody else's trademark, that person can be held liable. All right, and also it is illegal to register a domain name without the consent of a person or without the intent of of doing any business with it, but just to profit by selling the name for financial gain. Right, so those were the main purpose of this law, a U.S. Anti-Cyber Squatting Consumer Protection Act. So as you can see, as the internet becomes more and more complex, the laws have to keep up with these changes to protect the interests of businesses, right? And the question is to what extent the laws in our countries are able to keep up with it. Okay. Now, if you look at the technologies in internet technologies, that also has created quite a lot of issues. All right, and there are three areas of concern with respect to trademark infringement, and one is called deep linking. All right, I've added these what do you call it, YouTube videos in these links. But what is deep linking? All right, basically deep linking is where you see that users move from one site to another through the process of hyperlinking, right? So that means that that is they use a certain language to actually take consumers to another website. All right, and that is what this is all about. Right now, I'm not going to play this video right now. Right, I would like all of you to perhaps just see what that video is about. All right, the next is about meta tags. Okay, again, these are all codes used in software, whether it's deep linking or meta tags or framing. All right, all of these are codes used. All right, in the what do you call it? In these websites, right? And a lot of it has got to do with marketing. All right, marketing, strategies, so that people would actually get hits whenever the consumers visit these websites. All right, so again, you can see one is hyperlinking, the other is meta tags. All right, and then finally there is framing. All right, now what is a meta tag? Okay, meta tag is actually an invisible code embedded in the hypertext markup language, which is used to create websites. All right, and it's usually used to assist a search engine to index and summarize sites. So sometimes when you key in certain words, you'll find that these keywords are picked up. All right, and then they would actually see which are the sites that have those keywords, and then you will get a list of these websites. All right, so that's meta tags. All right, and then framing. All right, which is you'll see that allows a website to use when they're going to one website, they can also see the contents of another website. All right. So that means each of these websites will have more than one HTML document. So therefore, when you go to that website, you'll find that there are two frames, right? Uh, Depicting two different websites, or sometimes even more than two different websites. All right. And these websites are usually independent of one another. So these are examples of internet technologies that could possibly give rise to trademark infringement and trademark dilution. Okay, if you see framing, for example, especially if you did it without authorization, and this the consumer gets these two unrelated website. One is yours and one is somebody else's. And if this is done without your authorization, of course, that could be trademark infringement because they're using your trademark, etc. All right. So these are examples of possibilities how internet technology can make trademark infringement and trademark dilution occur more frequently, and also it makes it much easier to happen as well, right? Okay, now, so if you look at deep linking, all right, you can see deep linking is a hyperlink. Okay, it's a link on one site, generally in blue, to another site on the internet. All right, so homepage shows the banner, right? And owner's trademark. Okay. Now, so what happens is when this happens, as you know what a banner is, right? I think all of you would have known because you are marketing students, right? So if you look at the home page, it'll show the banner ad. All right. Normally, banner ad means it pays the website owner a fee based on the number of hits and owner's trademark. All right. So the homepage will show the banner ad as well as the owner's trademark. Right. So that is what you call deep linking, and this can sometimes result in a lot of losses for the business, right? Especially for non-commercial sites. Okay, so what happens is it makes you bypass the home page. Okay, so the whoever the user is may sometimes think that or have the impression that the product or service described belongs to the wrong company. So actually, because through deep linking, you're not aware you're being taken to another website. So the original company may lose a lot of money. All right. So the case on point is Ticketmaster Corporation versus Microsoft. All right. And in this case, again, the Ticketmaster sued Microsoft for creating deep links in the Microsoft Seattle Sidewalk website. All right? Now, basically, what happens is Ticketmaster actually sells, all these, tickets, all right, to certain shows and so on and so forth. But people who click that Ticketmaster's, uh, you know, um, website, because of these deep links, when they click, they're automatically taken to Microsoft's website instead of being taken to Ticketmaster's websites and sales pages, etc. Right? So it bypasses Ticketmaster's websites and take them straight to Microsoft's Seattle Sidewalk website because of the deep link. All right. But Microsoft denied and said that it had the right to control the way in which its site was displayed on another web page. All right. So Ticketmaster then sued it for trademark dilution and fair trade under Lanham Act. Lanham Act is a trademark act in US and California state law, right? And then Microsoft then sued counterclaims saying that the practice of linking websites does not violate US law, right? So what did the district court in Los Angeles hold? It held that the deep linking by Microsoft was illegal, all right? And Microsoft's commercial use and appropriation of this Ticketmaster's name, mark, and website had enhanced its own website because consumers had taken from Ticketmaster's website to Microsoft website, right? So definitely Ticketmaster is going to lose business and lose money, right? So also Microsoft have published misleading information about Ticketmaster, with regards to ticket sales, and therefore it had diluted the value of Ticketmaster's business relationship with MasterCard. So can you see or not? So how here, the court looked at, what was the intention here of Microsoft? Wasn't a good intention, right? So, and definitely the way they deliberately wanted the customers to come to their website. And they did that by using deep linking, right? Now, meta text, another area of problem, all right? Here, whenever a user seeks information on a search engine, all right, there is a competing company will put an invisible meta tag based on your keywords, and it'll take you to another company, all right. And consumers may actually think that that company has got affiliation with this company, right? And this could also lead to trademark infringement, trademark dilution, or unfair competition, right? So again, now you can see here another problem with meta tags, right? So by analyzing key terms included in the meta tag, the company may be detected to be using a registered trademark that has nothing to do with the company, but basically the aim is to lure users to its website, right? And this is called invisible trademark infringement. Invisible because basically consumers are not aware this is happening, all right, because it's based on the keywords that they type in, all right. And this case, Brookfield Communications Incorporated versus West Coast Entertainment Corporation, the court described meta tag trademark infringement as posting a sign with another trademark in front of one store. So equivalent, like a physical store, you're putting another business's trademark in front of your own stores, giving the impression that you've got some connection with that trademark. And that is what a meta tag does. All right. Another case, all right, you've got Playboy Enterprises, all right. The defendant had used the trademark Playboy in machine readable code by hiding it in defendant's web pages. All right. So they they use this in their web page so that whenever anybody types the word Playboy, it may actually it may actually take that person to this particular defendant's website. All right. So the hits identified by the search engine reflected matches between the search terms and the terms found in the HTML pages. So users looking at Playboy on the search engine would find Playboy on the defendant's meta tags hidden in its HTML code pages. All right. So here, Playboy Enterprises actually brought a case against the defendant. All right. And this tried to get an injunction from the court. Injunction meaning try to stop these people from using that particular code in their meta tag. All right. And then also equitable relief, that means some damages for trademark infringement, dilution, and unfair competition by defendant's website. All right. So here the court said that there was good reason for them to issue this preliminary injunction order. What is preliminary injunction? That means the court, before the case is heard, they will give the injunction if they find that there is a possibility that the plaintiff will suffer greater losses while waiting for the case to be heard. All right, but if the plaintiff wins the case, then they will get a permanent injunction, right? So what is this unfair competition? That means they are having an an unfair advantage by using plaintiff's trademark. Okay, and that is unfair competition, right? Because normally when you talk about marketplace competition, there has to be a healthy competition and it has to be fair, right? That's why monopoly businesses that are that are a monopoly in the marketplace, they are considered as providing unfair competition because they're dominating the marketplace. And so small businesses don't have any possibility of competing in that marketplace. Okay, so this now in Malaysia we've got competition law, or the Competition Act, and that is to regulate unfair competition. Okay, and then finally we come to framing. All right, so framing occurs when the link site is brought into original linking without advertising or other data annexed to the link site. So in the framing site, domain name remains displayed at the top of the web page, but then there could be another frame of another website in that website as well. All right. And this was demonstrated in the case of Washington Post Company versus Total News Incorporated. All right. Now, this is the case. All right. Plaintiff news content providers, they disseminate news. All right. Defendant is an aggregator of web news sources, meaning they not only take news from plaintiff's website, but other news websites, and they put it together in their site. So that's why they are called an aggregator of web news sources. And they use this frame technology for that purpose. So that means that when you go to their website, you also see plaintiff's website and other websites that are also news sources. Okay, so plaintiff sued the defendant for commercial misappropriation, trademark infringement, and trademark dilution. And they claim that Total News unfairly piggybacked on their content and work, right? And therefore, they unfairly benefited from the work that they had done in terms of providing news, all right? So defendant claimed that it's a user's choice and how he or she wishes to view a website. Now, however, who won the case? Okay, and the court, gave decided the case in favor of the plaintiff, gave them injunction, and then told Total News to stop framing plaintiffs' websites. Okay, so that's an example of framing, right? As you can see, how internet technologies can cause businesses, losses because of these kind of practices, right? So I will stop here. All right, and hopefully all of you have got some basic understanding on this. So we finished the topic of internet trademark disputes. Okay, thank you. Everyone stay safe.